That's hard to say because I think so far the case has been going well for us.
That's a great question. As far as I'm concerned, we're winning the trial.
So now that Judge Glanville is removed from the YSL trial, what's next? Well, as we all know, first the trial was assigned to Judge Shakura Ingram, and after just a couple of days, she stepped aside. So now Judge Whitaker is going to have the trial. Let's just assume for now that Judge Whitaker is going to move forward. What's going to happen from here? We have a lot of evidence that the YSL attorneys, including Doug Weinstein, Max Sharp, Brian Steele, and others, are all preparing motions for a mistrial.
So I know you don't like to talk about next steps, but are you going to call for a mistrial? I mean, it seems bizarre to
Yeah,
me.
I'm going to
The
call
idea
for a
that the
mistrial.
trial would okay, yeah. The
Yeah,
idea that the trial would just continue. I'm like, how could that possibly? I mean, it seems like any judge would be like, no, we're not just going to bring the jurors back and continue testimony. Like,
yeah. I mean, I've been working on a motion for mistrial, certainly the research aspect of it for a while, because again, we're trying to prepare for whatever eventuality happened. So yeah, we'll at some point soon be preparing a motion, well, finishing a motion for a mistrial. And you may see multiple motions for mistrials.
yeah.
Now, if a mistrial were to be declared, there's basically two ways that this could happen. One would be with prejudice, and the other would be without prejudice. With prejudice would basically mean that the state did something so bad or so wrong in the current trial that it shouldn't even have the ability to bring the trial back up. So this is what happened in the Alex Baldwin case, where the judge declared a mistrial with prejudice, which means that the prosecutors cannot bring the case up again. A simple mistrial without prejudice would mean that the state can bring the case back up again, so it would just depend on the prosecutors as to whether they would want to start from scratch, basically, with selecting a jury and starting everything all over.
But it also seems like, and Doug Weinstein has been upfront about this, that your end goal is an acquittal.
Right.
You don't just want to have to restart the trial again. You want to get a not guilty verdict from
Right.
the jury. And it seems like, just from somebody who's been watching from afar, the complex charges, like the murder charges, the RICO charges, the RICO charge, it just seems impossible to get any kind of conviction on that based on what they've presented. So because of that, is there kind of a unique interest in trying to see this continue under the current jury?
That's a great question. As far as I'm concerned, we're winning the trial. As far as I'm concerned, none of the testimony has touched us. It's touched my client in particular, Shannon Stillwell, but it's touched anyone in any meaningful way. So you don't there from that perspective, you don't really want to start over.
So that's one thing. We have these mistrial motions that are hanging out there, and it's almost certain that the new judge is going to rule on those mistrial motions right at the start, I would imagine, before getting back into testimony and those sorts of things. So that's one. Also, two, we have this kind of lingering situation where Attorney Steele in particular is going directly at Adrian Love. He has wanted to get her in particular off of the case for quite some time. He has filed numerous motions to have her removed from the case, the most recent of which came with his supplement on July 8th, 2024. I'm going to read a little bit of this so that you kind of get a sense for where Steele is coming from, but we're also going to show a previous motion from April where he also tried to get her off the case. So I imagine if they don't get the mistrial, Steele is going to continue to go at Adrian Love and try to get her off of the case because I suppose in his opinion, Adrian Love is one of the biggest impediments to Mr. Steele's client, Young Thug. He sees her as one of the biggest impediments to getting Young Thug a fair trial. So I'm just going to read this paragraph real quick so you can see how Steele goes about trying to get Adrian Love off the case. And in this situation, he actually went at Love and Hilton. So he said, Mr. Williams' trial is constitutionally broken based upon the unconscionable misconduct of Judge Glanville, Lawyer Love, and Lawyer Hilton. all working together in an effort to convict Mr. Williams. The criminal justice system in Fulton County, in the state of Georgia, and in America has been attacked by the conduct of these three actors. The injustice must end immediately, beginning with Judge Glanville, removed and disqualified from Mr. Williams' case. So, quick note, that's already happened. Thereafter, this motion is also timely made for Lawyer Love and Lawyer Hilton to be removed and disqualified from Mr. Williams' trial, and Fulton County District Attorney's Office must be investigated for their improper conduct, if any, outside of the actions of Lawyer Love and Lawyer Hilton. So you can see there that Brian Steele is serious. You know, he didn't just go after Love in this one. He actually went after Hilton as well. So they already got one of the three gone, right? Glanville's already gone. And now I think Love is going to be up next. I think if they don't get the mistrial, we're going to see Steele continually going at Love to try to have her taken off of the case. So that's where we stand, basically. You're going to have mistrial motion after mistrial motion for the new judge to rule upon. If none of those succeed, the trial will continue. I think Woody is currently on the stand, so they're going to have to get Woody back on the stand if he's still the prosecution's witness. Also, the defense should have an opportunity to interview Woody. And if no mistrial is granted, then everything will continue. One interesting note about the mistrial is that, as I stated, if it's a mistrial without prejudice, the state could bring this trial, they could just start over again or start over again when they want. They could even sit on the trial for a while, sit on the charges for a while and bring them back up maybe in several years, depending on the statute of limitations and that sort of thing. So what's really interesting is that at least two attorneys associated with this case have expressed some kind of understanding or some kind of inclination that they may actually be winning right now.
All right, our next one says, but if you also don't think the case will be rewound, then would that mean a mistrial? Or do you believe that that favors your client's case?
Well, if you can't really rewind the case, then a mistrial would be the only appropriate outcome at that point. Would that be in our favor? That's hard to say, because I think so far the case has been going well for us. And I hate to see this whole thing start over again.
You know, that's a great question. As far as I'm concerned, we're winning the trial. As far as I'm concerned, none of the testimony has touched us. It's touched my client in particular, Shannon Stillwell, but it's touched anyone in any meaningful way. So from that perspective, you don't really want to start over.
So what's interesting is they will probably be asking for a mistrial for a trial that they think that they're currently winning, which is very interesting. So what do y'all think about that? What do you think about the fact that they may be looking to get a mistrial for a trial that they could very well be winning? That's quite an interesting concept as well, because if you're winning and then you have to start over, you know, like Weinstein said, the state will have learned certain things and the state will have modified its approach. And now the advantage that the defense had, they might not have it anymore. So what do y'all think about that concept? Let me know in the comments. And again, like, subscribe, and thank y'all for watching.
Your Honor, so Investigator Randolph would be around that area. I have no idea what you heard. You remember tearing up when I asked you about Dominic Thomas. So did we talk about him getting killed when you and I met? Did you indicate that it was messed up what happened to him? I didn't, nobody did this. Ms. Love injected herself into the proceedings. There's not a waiver here. She decided to do it on her own. We don't have to sit here and stop her from becoming a witness.
Did you object at the times that she said all these?
There's no objection.
By any of you? No. But don't you have to object, preserve the or let the court know at that point in time? That's one of the issues that the state's raised, is that you all failed to timely object.
Yeah, the state was wrong. The state was wrong. But respectfully, because this is not on an appeal where I didn't ask for her to become a witness. The case that the state cites is the contemporaneous objection rule when you want to stop the question. Ms. Love decided voluntarily and freely to interject herself in the proceedings. There's no objection.
But no, you still have to
becoming a
object.
witness. No.
I disagree with you. You still have to object as soon as you realize that there's an issue, that to preserve the issue so that the appellate court doesn't kind of tell you waiver, right?
But what's the issue?
The issue is what you just told me.
No,
that she's injecting herself as a witness.
And that's okay.
I mean, that's what your allegation is.
That's okay, though.
Okay, but that kind of at least preserves the issue for the court to consider then and make a ruling on it.
The court is considering now, did Ms. Love become a witness in the case?
All right, then the other thing is we haven't completed the examination of Ms. Bennett. So all the conversations, and this is why I asked you to kind of limit as to the conversations that you believe Ms. Love had, and there's no other third party, because you can certainly examine the witness about those particular statements that were allegedly made, or the third party can be examined at some point. Okay, sorry. I'm sorry. So that's why I asked you. I'm more concerned about those conversations that you claim where it was just Miss Love and the witness, and she is purportedly, as you said, interjected herself into the matter.
So I gave you two pristine examples that cannot go without the jurors understanding it. The first one is, did you send, this is Ms. Love's words, did you send a communication to anyone in district attorney's office stating you did not care what the judge said, no one could make you testify, and did you give explicit instructions as to what to tell the judge to do? That is a question. The answer is no. The answer is no. Ms. Bennett said no. So there's nobody else in this planet that I can go to ask, why did Ms. Love say that?